Hello, everyone. Good morning.
Can you hear me?
I can hear you. Good morning, Isabella.
Good morning, Sam. How are you?
Great. We're going to start promptly at 10 o'clock.
Sweet.
Good post, Terry.
I'm really excited today. We've got a great speaker joining us. One of my attorneys that works for me is getting on the call now. His name's Gary Green. So you guys are really going to enjoy this. So let's get going. There he is. Hello, Gary. Gary, can you hear me? Gary. Hey, Gary, can you hear me?
I don't think your volume's up on your speakers. Oh, I need to turn off the radio.
Hi, Gary.
That would help. Now go back to your camera.
Gary, can you hear me now?
Yeah, there you go. Yes.
All right. We're good to go. We're going to start in about 5 minutes, everybody.
So
Hello, Marty.
this is
Yes.
good.
Morning, Joanne. Hi. See you on the call. Hi, Bob. Mona.
Good morning, sir.
Hope you're doing well. We're going to get started in about 3 minutes. All right, everybody, we're going to start in about 1 minute. I'm going to go ahead and share my screen. Okay, hope you can all see the slide. Let's get the chat open. Okay, it is 10 a.m. We are going to get started. Thank you all for joining today. I'm very excited. We're going to talk about what the realtor needs to know about evictions. I'm also really excited about this presentation today because I have a guest speaker. My Senior Litigation Counsel, Gary Green, is on the call. He's going to walk us through what the realtor needs to know for evictions. Start off, of course, we are lawyers, so we have to have a disclaimer. We are going to be giving you lots of good information today, but the attorney-client relationship only can be begun with a initial client consult and an engagement letter. A little bit about our offices. Of course, we were founded in 2007, and we're dedicated to real estate and business law. We help small business owners, entrepreneurs, buyers, sellers, property managers, and others with their real estate and business needs. Don't forget, of course, as a realtor, you're a small business owner. So we're happy to help you form your corporations, your LLCs, or any other business matters that might come up. Gary, of course, heads our litigation department, and we have offices throughout Southwest Florida. A little bit about me. I've been doing this since 2003, and I focus on transactions. I'm a member of NABOR, the Real Property and Trust Probate Law section of the Florida Bar. I am a recovering politician, so you have to excuse any jokes later. A little bit about Gary. He's going to take over. He's our Senior Litigation Counsel. He's been an attorney for 25 years. Knows a heck of a lot about evictions and is really excited to talk to you today. And so, Gary, why don't you take it away? Let us tell us a little bit about yourself and what you're going to be talking about today.
Sure. Good morning, everyone. Again, my name's Gary Green. I handle the litigation for the firm, and that includes evictions, and we do a lot of them. I think In the 5 years that I've been with the firm, we've done hundreds. And I'm proud to say that we have 100% success rate. So knock on wood with that. This morning, I'm going to discuss the various types of eviction. The first 4 or 3 bullet points on your slide. I'm going to talk about terminating various types of tenancy. I'm going to talk about serving notices with regard to all of the above. And then I'm going to talk a little bit about unlawful detainer, which is similar to an eviction. And then finally, I'm going to give some comments regarding the previous COVID-19 moratorium. I'm going to pause at various points to take questions. So feel free to ask any questions you have.
You can always put your questions in the chat as well, because I'm monitoring the chat.
All right, so if we go forward, Sam. All right, so the most common type of eviction is for non-payment of rent. When the tenant doesn't pay the rent, the landlord gives a 3-day notice for the tenant to either pay the rent or vacate. Important to note that the notice, the amount claimed in the notice can only include rent, principal rent, no late fees, no interest, no utility payments, only principal rent. Also important to note that in calculating the 3-day period, you don't include weekend days or holidays. So it's important to make sure that your deadline of 3 days is accurate with regard to that. Finally, if the landlord accepts partial rent during the 3-day period, then a new notice is required. So you start over and give a new notice with the amount that is now due after application of the payment. If no payment is received and the tenant does not vacate within the 3 days, then the landlord can sue to evict.
Gary, we have a
And
question in the chat. Sorry to interrupt you. We have a question in the chat. If the client has been renting, if the house goes up for sale and the client's been renting it out, how do they terminate if there's a 1-year lease? And isn't, I think the answer is.
And we'll get to that.
We'll get to
That
that.
question will be answered. In non-payment of rent cases, the tenant has to both file a written answer with the court once the landlord sues to evict, and they also have to deposit into the clerk registry the amount of rent that is alleged to be due in the eviction complaint. So, you know, very often, even a tenant that answers that fails to deposit the rent amount is defaulted by the court for failure to do so. Any questions about non-payment of rent evictions?
I don't see any in the chat. So, Isabel, you have a question?
I took a class in Larson, and they said, like, if the payment is due on the 1st, the 3rd day, you can give them notice that if they don't get the rent, you can actually evict them, like call the sheriff and get all their belongings put out on the curb. Is that true? On the 3rd day?
No, ma'am. No, ma'am. On the 3rd day, you would be able to file your eviction lawsuit. And that has to go through the court process. Evictions go under what's called summary procedures. So they move quicker than normal cases. And the tenant would have 5 business days to answer the eviction complaint by filing a written answer with the court. And in this case, as I mentioned, depositing whatever amount was due into the court registry. If the tenant does both of those things within the 5-day summon period, then the tenant is entitled to a hearing to determine whether an eviction is appropriate. So that hearing would then be set by the court at least a few days beyond the filing of the answer. The hearing would occur. The court would rule. If the court ruled that an eviction was appropriate, the court would issue a final judgment. Once the final judgment is issued, the clerk would issue a writ of possession And then once the writ of possession is issued, it would go to the sheriff who would then serve it. So all of those things would have to happen. The 3-day notice does not cause the eviction to happen. It just allows the landlord to file for an eviction.
Gary, I have another question. David is asking, can you refuse a partial payment?
Yes,
Okay, good. Amy is asking, if you run up a water bill and you don't pay that, it goes past the end of the lease, can they leave and still owe the water bill? And what is the remedy?
you could sue them for damages.
Okay,
But again, you would not be able to include that water bill in the 3-day notice. It would, to do so would render the notice defective.
and Maria's asking, this process takes like a month, I would say 5 or 6 weeks.
If the tenant defaults, meaning they fail to file an answer and or deposit money into the registry, we can usually get them done within a month. If the defendant files an answer and deposits money into the registry, that time is extended by a week or 2 so that the court can have a hearing. Just depends on the court schedule.
Okay. I don't see any other questions. Let's move on.
All right, so we have a statute. And the next type of eviction is failure to comply with that statute, which is 83.52, or a material provision of the lease. So 83.52 requires a tenant, any tenant, to comply with all codes, to keep the premises clean and sanitary, to keep the plumbing clean, sanitary, and in repair, to reasonably use and operate all facilities and appliances, to not destroy, damage, or remove part of the premises, and to not unreasonably disturb neighbors or breach peace. Obviously, the lease can and usually does impose additional obligations upon the tenant, but these statutory obligations exist even if there is no lease. So you may have an oral tenancy, and even though there's no written lease, the tenant is required to comply with these provisions. If they fail to comply with any of these provisions or with any material provision of the lease, then next slide, Sam. Then the first thing you determine is it curable, the non-compliance, or is it not curable? And I'm going to skip the order of this slide, but examples of curable non-compliance include having a pet you're not allowed to have, having additional tenants that shouldn't be living there, parking vehicles, failing to keep the place clean. These are things that can be fixed or corrected. Therefore, they are deemed to be curable. And if the violation is such a curable violation, then the landlord would serve a 7-day notice to cure or vacate. Note here that unlike in the 3-day notice, it's 7 calendar days, including any weekend or holidays. Again, this is for any violation of the prior slide, statute 8352, or of the lease. And I've discussed the examples. Another example that some of you may have run into recently is failure to give the landlord access for the purpose of showing the premises for resale. I know the market's hot, and so a lot of landlords and their agents, which may be you, are attempting to get into properties that have tenants. And there's actually a separate statute that addresses the issue, and clearly the landlord has the right to enter the premises for that purpose upon reasonable notice. And it's also in the standard Florida lease. So a violation of that, failure to allow the landlord or his agent to show the place, would be one that you would give a 7-day notice to cure. They would have 7 days to obviously give access for that purpose, and if they did not, the landlord can sue to evict. And that's the case for any violation of either 8352 or the lease that is curable. If they don't cure it or fix it within 7 days, the landlord can sue to evict. Next slide, Sam. So some violations or non-compliances are uncurable. These would include intentional destruction, damage, or misuse of the landlord's property, or a subsequent or continued disturbance. I would also lump in there, although it's not mentioned in the statute, criminal conduct. There is case law. I'll give you an example. I had a case where, and that would be violence, drugs, running a house of ill repute, whatever you might have. But I had a case where a tenant fired a weapon in the condo, and it actually went through the wall and came within inches of striking the neighboring occupant. So, that would have fallen in this, and did fall in this category. But here it's not a 7-day notice to cure, it's a 7-day notice to vacate. And again, we're talking 7 calendar days. Not only does it include the types of things, the damage, destruction, misuse, and subsequent continued disturbance, that's from the statute, the language in the statute. It also includes subsequent or continuing curable violations. So let's say that the tenant has a dog and you serve him with a 7-day notice that the lease says that no pets are allowed, and the tenant removes the dog, everything's good, they've cured the violation, you go about your business, and then 6 months down the road, the tenant's got, another dog. You wouldn't have to do a 7-day notice to cure in that case. You could do a 7-day notice to vacate, because it would be a subsequent or continuing non-compliance within 12 months of a written warning of similar violation.
Gary, does that go the same for if they refuse showings, more than one showing in a row after being noticed?
I would agree that would, if you've given them notice that they have to allow a showing, they allow the showing, and then 2 weeks later you want to show the property again and they don't allow the showing, it's now not curable. And the 7-day notice would be not to cure it this time as it was before, but it would be to vacate within the 7 days. If they do not vacate within the 7 days, the landlord can file their complaint to evict.
Okay, that was one of the questions in the chat. David was asking, what happens if they don't leave on the 7th day? And the answer is you file your eviction.
You file your eviction on the 8th day.
All right.
Any other questions on non-compliance eviction?
Can a lease in Florida be valid for more than a 1-year period?
Yes.
And they got rid of the witness requirement last year, so you don't have to have witnesses on more than a 1-year lease. But as a realtor,
I don't
you are
suggest.
not allowed, as a realtor, you are not allowed to enter into a lease for more than 1 year. So if you have a multi-year lease, you need to have it blessed by an attorney.
I agree. And there are pitfalls to multi-year leases, and I don't advise them. The standard Florida lease that I recommend be used requires that a new lease be signed each year. And if the new lease is not signed for the subsequent year, the lease terminates and becomes an oral month-to-month tenancy at will. I recommend that form for various reasons. And I'm going to talk a little bit more about how that works here in a minute. So any other questions about non-compliance evictions?
I think we're good.
All right. So some tenancies are called tenancies at will. And this is when there's no written lease. There's an oral agreement for the tenant to pay whatever amount the tenant is supposed to pay periodically. Okay, and the notice that's required to terminate a tenancy at will depends on how often the rent is paid. And you can see here on the slide that if they pay, let's say they pay a year in advance, then they get 60 days notice. If they pay every quarter, 30, month to month, which is the most common, requires 15 days notice. And I think a lot of people misconstrue the statute and think that month to month tenancies require a 30-day notice, but they don't. What the statute requires is that the notice be served at least 15 days before the end of the rental period. So it depends on what day you are. Today we sit on the 8th of December. So if I had a client that called today and wanted to terminate a tenancy that was month to month, as long as we had that notice served before the 5th, on or before the 15th, there's 31 days in December. So by the 15th, we would have to serve them with that notice. If by contrast, they came to me on the 16th of December, then I would have to file a notice that terminated the tenancy at the end of January, because I would have already passed the 15-day threshold. Week to week requires 7-day notice. Important here is that any tenant that holds over and doesn't leave after the notice, whichever notice is appropriate, you then can obviously sue them to evict. If you do sue them to evict, a holdover tenant is liable for double rent pursuant to the statute. The tenant is also entitled to attorney's fees for any type of eviction pursuant to the statute. But in the case of holdovers, the landlord gets double rent.
Now, Gary, in terms of strategy, if the realtor is going to serve a 15-day notice to terminate, their client asked them to do that, and it is December 16th, wouldn't it be better to wait until the January rent is paid and then serve them prior to January 15th? So you make sure you
I would
get
advise
rent
that
for
because
January?
that increases the likelihood that you get the January rent,
Yeah,
right?
is that
If they know they're on the way out, they may not pay.
right?
So I agree that that would be strategically smart. All right. Any
There's
Any
no,
other
there's been no
questions?
questions.
No?
No.
All right, so tenancies with a specific term, and this was the question that was raised earlier. You have your 1-year standard Florida lease, and what it states again is that the lease is for a period of 1 year. In order for the lease to be renewed, a new document is required for the subsequent year. I have a client, for example, that sent the new lease and the tenant chose not to sign the new lease. And at this point, the tenant is therefore a month-to-month tenant at will. So that landlord client can evict that tenant any month for any reason at all, just because it is now a tenancy at will. Some leases, if you're not using the standard Florida bar lease, may require certain notifications either by the landlord or by the tenant with regard to renewal or non-renewal of the lease. But in either event, the statutes state that a lease can't require more than 60 days notice with regard to either renewal or non-renewal. Again, if you have a tenant, for example, the same example of the month-to-month tenant, that client could have evicted or could have filed to evict that tenant at the end of that annual lease, because the lease had expired and that tenant would have been liable for double rent. Now, in that case, my client has chosen to allow that tenant to remain as a month-to-month tenant for now, for logical reasons. And, but as I said, she can evict him by giving 15 days notice before the end of any month. Yeah, I think that's all on that one. All right, services of notice, service of notice. Well, let me start here. All of the notices that we've discussed so far, all notices in eviction cases can be delivered by mail, hand delivery, or posting at the residence if the tenant is absent. We use a certified process server to serve all of our notices. It's important because it eliminates any dispute about whether the notice was actually served. If you send it by mail, the tenant can always say they didn't get it. If you post it yourself, the tenant can always say you're lying and you didn't post it. But when you have a third-party disinterested process server that actually files a return of service with the court, you've nailed that down and you avoid that issue. Notice requirements can't be waived in the lease. And that also means that the notice has to be correct. And if a notice is defective, then it can blow the entire case up. And for that reason, I recommend that notices be done by an attorney. I know that they seem simple, and a lot of times either property managers or realtors feel comfortable doing them because they've done them many times in the past without incident. But you'd be amazed at how many clients come to me and either they or their realtor or their property manager have served the tenant with notice that I wind up having to redo the notice because it's defective. So I recommend that they be done by an attorney and served by a process server. Again, I think it's well worth the expense in the long run, because if you get it wrong, it can be a fatal flaw. It can cost the client valuable time, and in evictions, timing is everything. So for what it's worth, that's my recommendation. We do notices for a flat fee. We charge $300 for the notice, and then there's a $50 expense for the service. But again, in my opinion, it's money well spent.
Gary, we have some questions on notices. Can a notice be sent by email?
No. By mail, hand delivery, or posting.
Is it the responsibility of the tenant or landlord to discuss the extension of the lease, and how many days notice do you need? I can answer this one. Mona, the landlord and the tenant need to discuss the extension based on who is obligated in the lease to make the proffer. So if the lease says, if the tenant wants an extension and the lease says you have to give 30 days notice if you want an extension, then the tenant should start the conversation. It's all in the lease.
And if the lease is silent as to that, then either party can initiate that conversation. So in other words, if I'm a tenant and I'm coming to the end of my lease, I clearly want to communicate with my landlord. And if possible, if I want to stay, I want to get a new lease, right? And by contrast, if I'm the landlord and I either want the tenant to stay or don't, I need to communicate that to my tenant.
Do notices have to go to every tenant, Gary?
Yes, but it can be a single notice that names all tenants if there are multiple tenants.
And then Yuri is asking if you can define defective notices. I think you gave.
Well,
some
a notice
examples.
can be defective in many ways. For example, a 3-day notice can be defective because it includes late fees rather than only principal rent. It can be defective because it fails to properly calculate the 3 days. A 7-day notice can be defective because it is a curable violation when the 7-day notice alleges that it's not curable, or vice versa. Notices can be defective because they don't include the necessary language that is required by the statute. So there's a plethora of reasons that a notice can be defective. And again, that's why I recommend that you have them drafted by an attorney.
Is the tenant responsible for the cost to evict?
If you file an eviction lawsuit and the prevailing party in that case is entitled to recover their attorney's fees and costs from the non-prevailing party. So if you win an eviction case, yes, the other side has to pay their attorney's fees. Now, keep in mind that often with regard to unpaid rent and attorney's fees and any other damages that might be incurred by a landlord during the eviction process, oftentimes the tenant's not recoverable. So the landlord then has to make a decision, and we file a damage claim with every eviction. Okay, so we would have a count for eviction in our case, and we would have a count for damages. But at some point, once the writ is served and the tenant is physically evicted, the landlord has to make a determination as to whether the landlord wants to pursue the claim for damages or for attorney's fees or both. Okay. And again, often that's an economic analysis based on the ability or the perceived ability to potentially collect a judgment against the tenant. You know, tenants that don't pay their rent and are forced to be evicted are typically not the kinds of folks that have assets that you can go against to collect a judgment. So that's always a consideration.
Dan is asking, what happens when an additional person enters a lease and was not included in the lease? I think he means additional person enters the property and was not included in the lease.
Yeah, well, that would be a violation of the lease. So the landlord would serve a 7-day notice to cure, because that's curable, because obviously the person can leave. And then the landlord would have 7 days, or there would be 7 days where the tenant would either have to get the person out of there, or if they did not, the landlord could sue to evict.
Yes. Should we talk about unlawful detainer?
Yeah, let's go to unlawful detainer if there aren't any other questions. So unlawful detainer, these are fun. These exist, this is cases that are like evictions, but there's no lease and the person isn't paying rent. So how does that happen? Well, it's usually a family member, significant other, boyfriend, girlfriend, friend, acquaintance, whoever a landlord or a property owner has allowed or consented to live in their property. Okay. When you have such a person and you no longer want them to live there, or they were living there without your permission to start with, it would also include a squatter. Let's say the property was vacant and unbeknownst to you, you went to visit and drop off some items at the unit, and all of a sudden someone's living there, right? Well, they're not a tenant. They have no lease. They have no rent. And you can't even call the sheriff to have them removed as trespassers, but you can file an unlawful detainer. No formal notice is required. So all that the owner has to do is inform the person, get out. And if they don't, unlawful detainer action can be filed. Same summary procedure as evictions. So they move fast with a 5-day notice. Major difference is that attorney's fees are not recoverable. Your costs are recoverable, which would be your filing fee and service of process. I said these are fun, and I say that tongue in cheek because these are always emotionally charged cases because they involve familial relationships 9 times out of 10. I had, so it's usually a breakup or a family split, which is even worse. I've had I had an unlawful detainer case that went to trial, and the boyfriend who was living in my client's home, and obviously they broke up, and she asked him to leave, and she owned the home exclusively. Believe it or not, people refuse to leave even when they don't own a home. And he was one of those people. He refused to leave. We went to trial. He came to court drunk, holding the infant child of his new girlfriend, charged the bench in an effort to express his frustration to the court, and was led away in handcuffs. So, and we were given an escort to the car. So yeah, they can be interesting. But again, they're just like an eviction. It's just for someone that doesn't pay rent. Any questions?
Gary, how long does a landlord have to file their damages claim after the lease ends?
Well, again, I file the damages claim when I file the eviction action. And I do that in every case. I can always voluntarily dismiss the damages claim if the landlord decides that it's not economically reasonable to pursue that claim against the tenant. But if I file the case with both, then I always have it if I need it, and I don't have to amend the complaint later to allege damages.
If it's
And
a pure
often
damages
landlords
claim
don't
afterwards,
know what the extent of the damages are going to be until the tenant vacates, and they get in there and they see that, oh Lord, they destroyed the carpet, and they broke the door off the stove, and whatever else might be done. And so I always leave that. I have a provision in my damage claim that states that they're also seeking damages for any damage that occurred by the tenants that they're not aware of at the time of filing of the complaint. So, you know, if the landlord decides to go that route, then it's already filed. If they don't decide to go that route, then we just let it go.
But it's a 4-year statute of limitations, right?
It would be breach of contract, which would be a 5-year statute.
5 years. Okay. Now the question was, how long do you have afterwards? So, okay. Last slide. No more.
So, yeah, I just wanted to speak a little bit about the COVID-19 moratorium that we've recently come out of, if you will. There were a lot of misconceptions during COVID. First of all, it no longer exists, okay? And this is the CDC moratorium on evictions for non-payment of rent. You wouldn't believe how many landlords called me once the moratorium was lifted, and they had multiple grounds for eviction other than non-payment of rent, either curable or non-curable violations of statute or the lease, termination of the tenancy, as we discussed. And it was only in cases of non-payment of rent that the moratorium applied at all. In other words, I'll go back, you don't need to, Sam, but any of the other, non-payment of rent, we have uncurable non-compliance, we have curable non-compliance, we have terminating the tenancy that we've been through. Any of those other methods other than non-payment of rent, evictions were going, and we were evicting people left and right. Even in the case of non-payment of rent, the tenant would have to file an affidavit. So once the landlord filed the complaint, the tenant would have to file an affidavit, which under penalty of perjury stated that they met certain criteria that were required under the CDC rule. And the criteria were relatively strict. In other words, if you were just someone that wasn't paying your rent, you probably didn't meet the criteria. Not that some tenants didn't sign it saying that they did, but even after that, and if the tenant didn't file that affidavit, then the eviction for non-payment of rent could proceed, even in the moratorium. Now, assuming the tenant actually filed the affidavit, then we were allowed to have a hearing as to the issue, where we could actually go through and cross-examine the tenant with regard to each of the criteria in the moratorium that were required for the prevention of the eviction, the eligibility for the protection. And the court treated it as an affirmative defense, which was interesting. And this is a new area of law. We had never run into this. But what that means is that the court put the burden of proof in those situations on the tenant to actually prove at that hearing that they met the criteria that's outlined in the CDC affidavit and were eligible, therefore, for the protection. And in the 2 or 3 cases that I had where tenants actually filed the affidavit and showed at the hearing, they weren't able to prove that. So again, at 100% success rate, even during COVID, even on non-payment of rent cases. So I say that not only to educate you about what happened in the past, but with all these new variants that seem to appear to be on the horizon, who knows what moratorium may, if it ever happens in the future, you want to be sure to consult with an attorney if you have a landlord that needs to evict, because again, 10 times out of 10, we got them evicted.
Dan is asking, what happens when the tenant does not appear in court?
Then they are defaulted, which
What does that
means
mean?
that the landlord wins.
Another question, on my question about having a 1-year lease and the home sold, does the landlord have to give notice by mail or can it be done by email? My client was told the owner was selling the home in November and was told they would have to be out by December. They were given all their money back, so they would move. Problem is finding a home to rent. Lisa.
Right, so, well,
Yeah.
it's going to depend on what your lease says. Okay, the standard Florida bar lease does not require any notice. Okay, it states unequivocally that the lease expires at the end of the year. So if you're operating under that lease, you don't technically have to give any notice. Again, I think it's obviously useful to communicate that you don't intend to sign a new lease. And that can be done by email or any other method, since there is no notice requirement. All right. But I don't know, I haven't seen your lease, and you may have a lease that does have some notice requirement. And if that's the case, then email would not be sufficient.
Um,
Does that answer the question?
Amy is asking at the end of the year or at the end of the lease, Amy, when the lease ends.
Whenever the lease expires, if you have the standard Florida bar lease, it says that there are no renewals without signing a new lease, that it can't automatically renew. And there's no provision in the standard Florida bar lease about notices for renewal. It just states exactly that. The lease is for 1 year. When the year is up, you will need to sign a new lease for the next year. And again, if that doesn't happen, they become a month-to-month tenant at will.
All right, so you have a bunch of questions coming in. Mona, how do you report a bad tenant that destroyed the rental property, but the police said it was not vandalism? Mona, reporting a bad tenant would require suing them and having it show up on their credit report. That's about the only report that I know. There's no database of bad tenants to my knowledge.
Not only that, the sheriff they're not going to arrest the tenant for vandalism. They're going to tell you that that's a civil matter.
Yeah. The home was sold. Does the lease go with the new owner? Yes.
It does.
Home is sold, the lease is transferable, the new owner takes subject to the lease, Lisa. Okay, if the seller is selling the property and the lease still has time on it, does the new owner have to honor the lease in place? Yes, Scott, they do. Dan is asking here, Dan is asking, can a realtor or seller make modifications to the lease? I think they mean the standard lease.
Yes, as long as the tenant agrees to the modifications.
I think for realtors, the important thing to know is that you should not be modifying any of the Supreme Court approved lease forms. If the tenant or the landlord want to negotiate something different, then you should have an attorney draft an addendum to the lease. But as the realtor, they're very strict about what you can do with a lease. You have to be very careful about that. Amy is saying the house is sold, but the new landlord doesn't have to honor the lease past the end of the lease.
Correct.
Yes, Amy, that's correct. When the landlord would not have an obligation to extend or renew a lease that they didn't want to stay in. And you can unmute yourselves if you want to shout out your questions, folks. Just go ahead. It sets the Zoom call sets, so you can unmute yourself. If not, just type your questions in the chat. Do you have any more questions? David is saying, what if they don't leave up north? We had to hire bonded movers and 3 months of storage unit. No, they don't have Gary, you want to speak to that about what happens if they don't leave? The sheriff takes them out on the day.
Yeah, what if they don't leave, then ultimately you get your writ of possession and the sheriff serves it, which basically gives them until the next morning to get out. And then he comes back and actually physically removes them if necessary. With regard to, you mentioned storage, if any items that the tenant leaves, the law allows the landlord to place them at the end of the driveway. Okay. It doesn't require you to store them. It doesn't require you to give the tenant any notice. Now, it does not allow you to otherwise dispose of the items. Okay. You can put them at the end of the driveway for the tenant to collect them. If the tenant doesn't collect them, then the garbage man's going to likely pick them up.
When extending a lease for another year, must you create a whole new lease, or is it an amendment to the extent to extend stating all the terms and conditions are the same? Is that acceptable?
I recommend that you do an entirely new lease. It's just going to be a matter of changing the dates of the term of the lease, and the landlord might, especially in this market, might want to consider a higher rental rate for each year.
Right. Lisa, I think you're misunderstanding. The client is a 1-year lease. The new owner wants them out. The new owner has to honor the whole lease.
Say that again.
The chat, Lisa is asking here, what good is a lease if the client is a 1-year lease and the new owner wants them out and they only been in there 5 months? And what I'm saying is that the landlord would have to honor the new lease for
For the
the
next-
entire term of the new lease.
Right.
Gary, what happens in a condo association where there's no driveway? What does the landlord do with the tenant's furniture? I think you
You
just
gotta
take
put it
to
outside wherever the trash gets picked up, right?
Yeah, that's what I would do. Take it to where the dumpster is for the condo.
Wherever you would normally dispose of.
It's
such
considered
items.
abandoned property unless you've signed a specific statutorily required, not required, but statutory notice under a different statute.
Correct.
Other questions people have? We seem to be slowing down in the chat. You unmute yourself if you'd like, or just put them in there. Seeing none. Oh, all right. Thank you, guys. Thank you all very much. I appreciate it. Gary, thank you for joining us today. This has been great. I hope
Thank you
everybody
very
learned
much.
something about evictions. If you have any questions, you can email Gary or I anytime. My email is on the screen and I will forward it to Gary. Thank you all. I appreciate your time today.
Can
Yes,
you, can you
Thank
email
you.
us the slides?
Yes, I will send out the slides. Yes.
Thank you, Sam, very much. Appreciate it.
Thank you all. Talk to you
Thank you
soon.
all.
Bye-bye.
Thank you.
Bye-bye.